Hey, did we get the signed waiver?
I'll leave travel, Judge.
Okay.
Well, may not show up for a couple hours, but it's
All right, I think sometimes. All right, perfect. All right, this is 20 MM 944, Chad Allen Watts. The state is present, defense is present. And counsel for the state of field, just for the record, announce your presence, please.
Yes, sir. Jose Corral on behalf of the state.
Miranda Treat on behalf of the state.
And for defense.
Donald Day, on behalf of Mr. Watts, who's present, we would also invoke the rule this time.
Would it specify and step outside?
All right, anything I know we discussed beforehand we started, but if anything else has come up in the meantime?
No.
We talked about?
No, Your Honor.
All right, then. State, you're ready to proceed?
Yes, Your Honor.
Mr. Day?
We are here.
All right. Anyone state wish to give an opening statement?
No, Your Honor.
Mr. Day?
We will wait, Your Honor.
All right, then call your first witness, please.
Your Honor, the state calls Diana Walton.
Told her to go because she's not anywhere on the first floor.
Oop, found her.
Ma'am, step up this way, please. Please face the clerk, raise your right hand, be sworn, please.
Please solemnly swear or affirm that the testimony you shall give shall be the truth, and nothing but the truth. I do.
This way, ma'am. Watch you stay.
All right, dispatcher, you may inquire?
Your Honor, may I proceed?
Yes, ma'am.
Good morning. Can you please introduce yourself to the court?
Yes, my name is Diana Jane Walton,
And how do you spell your last name?
W-A-L-T-O-N.
Ms. Walton, do you live in Collier County?
Yes, I do.
And how long have you lived in Collier County?
31 years?
And are you currently employed?
Yes.
Ms. Walton, do you know the defendant Chad Allen Watts?
Yes, I do.
And how do you know the defendant?
We had a relationship for 2 years. We were engaged.
And in what year did that relationship end?
May 2020.
Ms. Walton, do you see Mr. Watts in the courtroom today?
Yes, I do.
Can you please point to him and identify him by article of clothing?
Dark suit. Okay.
Your Honor, at this time, let the record reflect the witness has identified the defendant, Mr. Watts.
All right.
Ms. Walton, after your engagement ended to the defendant, did you apply for a restraining order?
Yes.
Do you recall when you applied for the restraining order?
June 5th.
And was the order granted on
Objection,
June
Your
5th?
Honor, calls for hearsay. She's not there when that order is executed. It's done in chambers. She could only know that happens by reading a document.
Sustained. Go ahead and rephrase your question.
Did you receive a restraining order against the defendant?
Yes.
Same objection.
Overruled.
Your Honor, at this time, I'm showing defense counsel what has been previously marked as State's Exhibit 1.
I've not previously been provided this exhibit, Your Honor. Just a second. Okay, let me let them do what they're gonna do before we get to this.
All right.
Can I approach the witness, Your Honor?
Yes, ma'am.
Ms. Walton, I'm showing you what's been marked as State's Exhibit 1. Do you recognize this?
Yes.
And what do you recognize it to be?
The restraint, the temporary injunction order that was granted.
Your Honor, at this time, the state enters into evidence State's Exhibit 1.
First issue, Your Honor, is I have not been provided a copy of that exhibit. I believe they are required to provide ahead of time.
Your Honor, this exhibit was provided in discovery to Mr. Day. This is a certified copy of the temporary injunction that was provided to him during discovery. And additionally, the certified copy was provided to Mr. Day.
Okay, there's the question. So when was that done?
About a certified copy or just a copy?
Certified.
Your Honor, it was sent on February 16, 2020.
That exhibit page number
2021.
21.
No, I don't have the.
Exhibit number is 75 through 79.
That the discovery that you just sent?
That was the discovery that was sent. Yes, 2/16, 2021 yesterday.
I don't have that one. The last exhibit I have disclosed yesterday is 31 to 74. Is it in the portal, Judge?
All they give me is a notice of discovery and it says 75 through 79.
I don't have that. I have what they disclosed, 31 to 74. Why don't we address the easy issues first, easier issues first? I would object, Your Honor, as it wasn't timely disclosed.
Your Honor, the state against position is that this copy of the temporary injunction was disclosed during the original discovery. This is simply a certified copy of that same injunction order that was disclosed yesterday.
The evidence code 9803 6C specifically provides that a party intending to offer evidence under paragraph B by any means of certification or declaration shall show reasonable written notice of that intent upon every other person and shall make the evidence available for inspection sufficiently in advance of its offer of evidence in order to give an opportunity to appear opportunity.
That applies when you're waiving the right of the custodian of record. The certification from the custodian of record is my understanding. Since this is a court file, I don't think they need a custodian of record. I think the evidence code says that it's admissible just as it is. It's self-authenticated.
Provided they provide us with written notice ahead of time, which goes to the timeliness of it. I'm going to assume they provided it yesterday.
Okay.
I don't have it. This is the problem with sending things the last hour before trial on the portal.
Always.
But, you know, is that timely?
Well, number one, we went over it this morning and you didn't have an objection at that point in time.
I didn't have an objection to what?
I asked you if you had an objection, and I went through the discovery notices that were sent as of yesterday, one of them being page 75 through 79, and you had indicated you did not. So even if you had, you've been provided a copy of it, not a certified copy of it. Just so tell me, assuming that there was a discovery violation, what you would have done differently, how it would have affected your trial strategy. I'm sorry?
It would not.
Okay, so the court's going to find that even if it was a willful violation, it's not a material violation. We'll overrule your objection. It'll be admitted.
So, Your Honor, we got to get to the other issues here.
Go ahead.
So the other issue, Your Honor, which has not been addressed yet in Florida that I could find, is whether or not the state can prove an element of the charge by the introduction of documents in violation of the confrontation clause. So I have not found anything with domestic.
I haven't, but I would tell you this.
Yep.
I can go back to I've never had anybody object to it. But I've had homicide cases where one of the elements is proving someone is dead. And I have introduced a death certificate from someone.
Yes. And there are specific instances where things are allowed. The courts have ruled that driver's license records are not.
So I don't see what the difference would be in this particular case. They have to prove a element of the offense beyond a reasonable doubt.
Yes. So
whether it is testimonial evidence or whether it is documentary evidence, I mean, it's clearly admissible as a public record. So my question then would be, I don't understand the distinction.
Okay, well, first of all, Your Honor, that is exactly the issue of whether it is testimonial or not. That's the issue that has to be determined.
Okay.
Courts have ruled, for example, things like death certificates, driver's license records, certain breath test records are not testimonial in nature.
Mm-hmm.
And the way that determination is made is the Florida Supreme Court has set the standard in State versus Contreras 979, Southern Second 896, case from 2008. And the Supreme Court went through the test for determining whether or not something is testimonial. And in particular, the beginning starts on case 5, where the court goes through its analysis. The court specifically found, in answer to your first question about being admissible simply because it's a business record, the court said, however, admissibility under this hearsay exception, and it's a third paragraph, right-hand column, Judge?
Yes, sir.
However, admissibility under this hearsay exception does not necessarily mean that the statements were properly admitted in evidence. An out-of-court statement is not admissible merely because it meets the statutory definition of child victim, and that was an exception to the hearsay rule, just like a public record would be an exception. The Sixth Amendment provides that in all criminal prosecutions, the accused shall enjoy the right to be confronted by witnesses against them. The U.S. Constitution, Amendment 6. The right guaranteed by this part of the Sixth Amendment differs from the kind of protection that is afforded by state evidence rules governing the admissibility of hearsay. And then under Head Note 6, the court addressed the issue of testimonial, and that was, as the court was well aware, with the Crawford opinion, what the standard was, but they went through that again under testimonial, and the Supreme Court said, while Crawford did not establish a precise definition of the terms testimonial. The Supreme Court did provide some guidance, holding that at minimum, statements are testimonial if the declarant made them at a preliminary hearing, before a grand jury, or at former trial, and in police interrogations. And then they cite Crawford. Next, the court goes to the unlawfulness, or I'm sorry, the unavailability of the declarant on the issue of Crawford, whether or not that issue is there. And on page 8 of the opinion, they address the issue of that as it relates to the Sixth Amendment. And then the last opportunity is, the last issue is on page 9, which is an opportunity to cross-examine. All of these things are criteria and factors that the court looks at. And in good example, perhaps, of what the court just asked me is in Washington versus State, found at 18 Southern 3rd, 1221. And that was a case before the 4th District Court of Appeal in 2009. And there was actually some building code records from the License and Contracting Board that was attempted to be introduced. And the certification was there, so they were properly certified, and the issue there was a certificate of non-licensed prepared by an employee of the State of Florida Licensing Division, Construction Industry Licensing Board, and attesting that such a search of its records revealed no one bearing the defendant's name held a license to engage in contracting was testimonial hearsay, and therefore its admission violated the defendant's Sixth Amendment right to confrontation and prosecution for acting as an unlicensed contractor during a state of emergency. Document was accusatory, was introduced to establish an element of the crime, was prepared at the request of law enforcement as part of an investigation, and was evaluated in the sense that it was not an existing record, but an assertion regarding a search. The document that the state seeks to introduce is a legal document signed by a court of competent jurisdiction, a judge, finding the defendant has committed an act of stalking. So it's making a specific finding of the commission of a crime, or at least evidence of the commission of a crime, although the burden's a little different in there. It's still the judge finding the admission of a crime. And it was part of a legal proceeding, prepared in that legal proceeding. So the fact that the court said that a licensing contracting documents were properly certified was testimonial in nature, I think is very, very similar to what we had before us in the injunction cases. It's not that they can't introduce the document. That's not the issue, Judge. The document can be introduced, it can be proven. The question is, do they need a witness to do it? That's the issue. So under Crawford, the things like driver's license records and autopsy reports and death certificates, things like that are not prepared in any way as part of litigation. They are something that courts have said is ordinarily trustworthy. They're not testimonial in nature. Those are different types of animals. In this case, we've got a court order making a specific findings of fact that the defendant in this case has some evidence of stalking and a granting of a temporary order. So it is clearly, not only is it based on specific evidence, it is testimonial in nature and provides a specific statement of fact by the judiciary, not an independent agency, by a judge, which raises a whole nother issue that really has not been addressed yet. And I think the 4th District kind of alluded to this in the last part of that opinion. Said, while we are plainly not dealing with a certificate or affidavit attesting to whether a substance found in the defendant's possession was in fact an illegal drug, we nonetheless find that in Melendez-Diaz persuasive. We thus hold that the trial court abused its discretion, allowing the state to introduce the certificates of non-licensure over the defendant's hearsay and Crawford objection. Such holding, however, does not entitle the defendant to reversal of his conviction, as we find error was harmless. So the document in our case not only is testimonial, it's a specific finding of fact by a judge that the defendant in this criminal case committed an act of stalking, and issue an order accordingly. So it is testimonial in nature. One of the factors is it an element? It's not that it's excludable just because it's an element of a charge. That's one of the factors that the Supreme Court said in reviewing whether or not it's testimonial. That's a factor. So it is an element of the charge. So for all of those reasons, Your Honor, we believe it is testimonial, and a Sixth Amendment right to confrontation would apply.
Maturino.
Your Honor, the state is going to argue again that course, it is a certified document. It is a self-authenticating document of a court document. And Miss Walton was present while it was executed. And the state's going to find that there's no statements of fact or testimony in this injunction that would violate Crawford. I don't see how it's testimonial, as the state is not entering it to prove he committed any stalking. We're entering it because we're entered an injunction for whatever reason. It's a certified document. It's valid, and it should be admitted into evidence.
One other thing, if we could address, probably need to make the record clear on this, Judge, in case this is ever going to be an issue.
Okay.
So I think it's important to note that the document that's being introduced isn't a jurisdiction, but that order of the court comes after the review of a petition for injunction for protection against stalking. That petition for injunction for protection against stalking is a document that was codified by the Florida legislature in format where there's a specific set of information that has to be included in there, one of which is a statement from the person seeking the petition with setting out a factual basis for the petition. And in this case, Exhibit 65 of the discovery given to us by the state through page 74 is that petition from Diana Jane Walton, the same witness that's on the stand today. I think it's important for the record to reflect, and I'd ask that this be made part of the record for legal argument. Not only is the exhibit finding of a court order making specific factual findings, it is based on an affidavit by the same witness in the criminal case alleging criminal wrongdoing. So I think that it gives greater weight to the fact that it is clearly testimonial in nature. So I'd ask that be made part of the record.
What's your exhibit?
It just marked as Defense Exhibit 1.
Okay.
And it's not for evidence, it's just for the record for argument.
Okay, Ms. Matrino.
And I'll hand it to the clerk, Your Honor.
Yes, sir. Any response? Mr. Cabrera, Mr.
Your Honor, Mr. Villa, what was it? Was
It's just a
page
petition.
65?
Yes, it's attached. In your discovery, it comes to pages after your exhibit you're introducing. So it's 67 to 74, I think.
Your Honor, also, based on the case law he presented, one distinguishing factor is that the defense admitted that licensing issue was prepared by law enforcement. This was signed by a judge. Also, defense counsel seems to be indicating that the only person that can enter this evidence through is the judge himself, as he signed it in chambers.
I'm not going to tell him how to do it, Judge, but there is lots of other ways to introduce the exhibit itself.
Wow.
So,
All right. All right, we'll let Defense Exhibit 1, it'll be filed in the court file for purposes of appeal, if there is any. Having a hard time making a distinction between this and a judgment and sentence that you introduce if you have to prove someone has a prior felony. That's been held not to be testimonial, and it doesn't fall under Crawford, and I'm not sure that this is any different than that. So I'm going to go ahead and admit the exhibit into evidence as a finding that it is not a testimonial where you do have a right to cross-examine the witness. I'm not even sure there's a declarant in this particular case, other than it's just a record. All right. So Exhibit 1, State's Exhibit 1 will be admitted.
Yeah. Ms. Walton, you received a copy of State's Exhibit 1, the injunction order?
Today?
No, at some point. did
Oh,
you receive a
yes.
copy of the injunction order? And did you at some point attend a hearing on June 15, 2020?
Yes,
And at that hearing, were you present?
yes.
Was the defendant present?
Yes, yes.
At that hearing, was this injunction extended?
Yes.
Your Honor, at this time, state showing opposing counsel was previously marked as State's Exhibit 2A. Your Honor, the state would request this be entered into evidence as State's Exhibit 2A, as it is also a public certified record of the order extending the temporary injunction.
Same argument, Mr. Day?
Well, I think that, I need to make the record clear here, that document is a lot less troubling. That document is not making a specific finding of anything.
Is there an objection?
Yes, I don't want to waive anything, and yes.
All right. So it'll be admitted as Exhibit 2A.
Thank you, Your Honor. Now, Ms. Walton, you did say you were present at the June 15, 2020 hearing?
Yeah.
Your Honor, may I approach the witness?
Yes.
Ms. Walton, I'm showing you what's been previously marked as State's Exhibit 2B. Do you recognize that?
Yes, I do.
And what do you recognize that to be?
That is a audio recording of that hearing.
On June 15, 2020?
Yes, correct.
And did you sign and date that hearing? Did that State's Exhibit 2B?
Yes, I did.
And did you listen to State's Exhibit 2B prior to taking the stand today?
Yes, I did.
And does that fairly accurately depict the hearing that occurred on June 15, 2020?
Yes, it does.
Your Honor, this time the state would like to publish, the state would like to enter into evidence State's Exhibit 2B.
Mr. Day?
Hearsay, Your Honor.
I agree.
Your Honor, the state would response is that this is also a certified copy of a public court recording that occurred. It's the judge's statements are not hearsay. And
Don't we have Exhibit 1? What's the difference between that and Exhibit 1? I don't care what was said at the hearing. Does it really make a difference? I'm not trying it all over again to decide whether that was done. We have Exhibit 1, and that seems like.
Your Honor, we have Exhibit 1 and 2.
Can I see Exhibit 1, please? So it would seem to me that's hearsay.
Your Honor, Exhibit 2B is just memorializing what's been previously entered into evidence of State's Exhibit 2A, which is the order that extended the temporary injunction.
Okay, well, that speaks for itself then. I'm not sure then why I need to have 2B. Is there any statement on there that's attributed to the defendant?
Your Honor, it's the state's intention to show that the defendant was present at that hearing and that he knew that this injunction order was in fact extended.
A indicates that the respondent was present with counsel.
Yes, Your Honor.
Okay, all right, so Exhibit 2B will not be admitted.
Yes, Your Honor. Ms. Walton, turning your attention to Sunday, June 21st, 2020. Do you remember seeing the defendant that day?
Yes.
And can you tell the court where were you?
I was at Naples Family Fitness.
And is Naples Family Fitness located at 2349 Vanderbilt Beach Road, number 550 in Naples?
Yes.
And that's in Collier County?
Correct.
And Ms. Walton, do you go to that gym often?
Yes.
And was the address of the Family Fitness, the Naples Family Fitness Gym specifically listed in the injunction for protection that you received against the defendant?
Yes, it was.
And was there any other address listed on that injunction?
No.
Was your home address listed on that injunction?
Yes.
Now, Ms. Walton, can you please tell the court what happened when you walked into the gym?
I passed the entry where you show your keypad. Went to go walk up the stairs to go to the treadmill. And I went left, and as I turned right up the second level of stairs, Mr. Watts approached me from the floor level and said, "Are you ready to talk now?"
Ms. Walton, when you first entered through the gym doors, did you see the defendant?
Not right away, not at first, no.
When did you first see the
As
defendant?
I was walking towards the stairs to go up.
And did the defendant see you?
Yes,
And as you walked up the stairs, the defendant approached you?
correct.
And what did he say?
He said, "Are you ready to talk about things now, or talk about this now?"
And how far away in distance would you say he was from you?
Probably about the same as you and I.
And after the defendant asked you if you were ready to talk, what did you do?
I just said I had nothing to say, and I continued on my way.
And was that up to the second floor?
Yes,
And what did you do then next?
I just got on the treadmill and put my earbuds in and did what I usually do, set the treadmill and start walking.
And while you were on, how long would you say you were on the treadmill for?
15, 20 minutes?
And while you were on the treadmill, did you see the defendant again?
Yes.
Where did you see him?
Walking towards the exit door by the, there's a cooler, like a vending machine that sits there with water and soda, I guess. I don't know exactly what's in it.
And what happened next?
Then he just kind of looked up and went the other way, and then I didn't see him anymore. And then I kind of noticed, okay, it's been a little while. He hasn't left, so I made the 911 call.
And were you able to speak to a 911 operator?
Yes, I was.
And why did you make the 911 call?
Because my attorney had initially told me that,
Objection, hearsay.
Sustained.
Did you make the 911 call because the defendant was at the gym?
yes,
After you made the 911 call, what happened next?
they dispatched the sheriff, the county sheriff, and they told me to come outside. They notified me that we are outside, could you please step outside?
And did you go outside?
And so then I went back down the stairs and went straight outside.
And when you were outside, did you see the defendant again?
Yes, that's who was me.
And did the defendant say anything to you?
Yes, he did.
What did he say?
He said, "It's all yours, I'm leaving."
Objection, Your Honor. Discovery violation. I've never been provided that in discovery. That happened. New story for today. So I object to that.
All right. Was this,
May I have more documents, briefly, Your Honor?
okay, go ahead.
Ma'am, you just said you were called down by the police. So when that statement that you said happened, the police were with you, right?
There was a police officer next to me when he said that, yes.
Okay. Nothing further, Judge. I'm going to waive that objection.
Okay. Go ahead, Ms. Metro.
Yes, Your Honor. After the defendant said it's all yours, I'm leaving. Did you speak to deputies?
Yes, they questioned me.
And you told them what happened inside the gym?
Correct.
And did you observe deputies speaking with the defendant?
Yes, they did.
And was the defendant arrested?
Yes, he was.
I don't have anything further, Your Honor.
approach him.
Yes, sir, go ahead.
Ma'am, when you had filed your petition for injunction, were you working at the time?
No,
Did you go to the wax place? Do you know a waxing place?
Objection, Your Honor, relevance?
I'll give you some leeway. I'm not sure where we're at.
In that same plaza, are you aware of a place that does waxing?
yes, I am.
Are we talking about, Mr. Day, are we talking about the Vanderbilt address?
Yes, Your Honor, same address.
All right. Go ahead.
The address where the gym is located, is that a large building complex?
Yes,
And multiple businesses within it?
correct.
And did you said you never worked at a wax place in that building? Does
No, sir.
waxing and eyebrows?
No, sir,
Did you ever go there?
never,
Did you work at any real estate offices in that location?
never.
And during the period of time that this incident occurred, when Mr. Watts was placed in handcuffs, you were outside when he was in handcuffs, correct?
Right.
And you recall taking pictures of him?
No.
Your testimony is you never did that, right?
No.
Okay. Other than the police,
Mhm.
so let's make sure we can establish who's there now. Mr. Watts is being handcuffed. Mr.
Right.
Watts, right?
Mhm.
Yes.
Correct,
There's the police.
yes,
Yes.
yes,
There's you.
yes.
No one else.
There-
You didn't have any friends or anyone
Yes.
else there with you.
Yes, I had a friend come, I had my ex-husband came, and my son came.
They're there when he's being handcuffed?
Yes,
Okay. Well, who was your friend that was there?
Doug Keating,
Okay. And your son and who else?
my ex-husband.
And did you see any of them take a picture of Mr. Watts?
I was so nervous, no, I don't recall.
So you don't recall or you didn't see it? Those
Your
are
Honor,
two different
objection,
things.
asked and answered.
Well, I'll let him clarify the question. Go ahead.
You don't recall or you didn't see it?
I didn't see it.
Okay. And were you with your son and those other people during the whole time?
Most of the time, yes. When they came right away when I called,
Okay.
they came and for support.
So you were with them?
Yes.
All right. And when that last statement that you said he made, was your son there for that? And those other witnesses?
No,
That was when they were putting handcuffs on Mr. Watts?
no, they didn't put handcuffs on him for about 30 minutes later. They were waiting for the transport vehicle.
Okay. So the police had him there.
Yeah, he was outside for about 30 minutes.
When you said he said to you, "It's all yours, I'm leaving."
After that, he was there about 30 minutes, correct?
Right. Police are there with him.
Yes.
Okay. Nothing further.
Any redirect?
No, Your Honor.
All right. Thank you, Ms. Walton. You may step down then. Okay, we'll call your next witness, please.
Your Honor, the state plans on calling Deputy Reed next. Do we have a brief recess just to speak with him for 2 minutes?
Sure.
Mr. Day, if you're not gonna get into this, I don't think you would do that.
Yeah.
Officer. Would raise your right hand, be sworn by the clerk, please.
Do you solemnly swear or affirm that the testimony you shall give shall be the truth, whole truth, and nothing but the truth?
Yes.
Yes, sir.
And procedure.
Yes, sir.
Thank you, Your Honor. Morning, officer.
Morning.
Can you please introduce yourself and spell your last name?
Deputy Robert Reed, last name spelling is R-E-E-D,
And where are you currently employed?
by the Collier County Sheriff's Office,
And how long have you been with the Collier County Sheriff's Office?
since August of 2018.
And do you have any prior law enforcement experience?
Yes, sir.
Can you tell me what that experience is?
I was a patrolman for a city in Missouri for a little over 6 years.
Did you go through any training to become a deputy?
Yes, sir.
Can you describe that training?
I went to the Police Academy in Missouri in 2011 into 2012. I have 3 years of college, and we have continuing education training yearly.
As part of your investigation, did you speak or interview any of the parties involved?
Yes,
Turning your attention to June 21st, 2020, were you on duty that day with the Collier County Sheriff's Office?
yes.
What was your assignment that day?
I was assigned to North Naples District 1 Road Patrol, day shift.
And did you respond to the Naples Family Fitness Gym?
Yes.
And what location did you respond to?
What is the address, or?
Yes, the address.
Well, 2349. I know it's unit 550. Apologize.
Is that on Vanderbilt Beach Road?
Yes, it's in the Galleria shop.
And that's in Naples, Florida.
Yes, sir.
Do you recall what time you got to the gym?
I believe it is roughly 9 a.m., 10 a.m.
And what information did you receive from dispatch?
That there was a lady calling that she had an active no contact order, and she was at that location at the Naples Family Fitness, and the respondent in the order was there at the gym and had communicated with her.
Who was the petitioner?
Diana. I apologize. I don't remember her last name. Walton, maybe? Miss Walton? I'm sorry.
And who was the restraining order against?
Chad Watts.
And was the address of the Naples Family Fitness Gym listed on the restraining order?
Yes, sir.
Was the defendant allowed to be at that address?
Not according to the restraining order, no.
What happened when you arrived at the gym?
I met with Mr. Watts, and I began speaking to him about what was going on. He provided me his copy of the restraining order that specifically listed Naples Family Fitness on there.
Did the defendant acknowledge that there was a restraining order against him?
Yes. Like I said, he provided me his copy from his vehicle.
Did the defendant acknowledge that he knew Miss Walton was a petitioner of the restraining order against him?
Yes,
Did he also admit that he saw Miss Walton at the gym?
yes,
Did he also acknowledge that he approached Miss Walton at the gym?
he stated that once he saw her, he was already inside the gym, prior to her getting there. And then he acknowledged to her, he didn't know what to do, and he asked her, do you want me to leave?
Did you tell the defendant that the restraining order prohibited him from being at the Naples family gym?
Yes, sir.
Did you tell him also that the restraining order prohibited him from having any direct communication with Miss Walton?
Yes.
Did you speak with Miss Walton?
I did speak briefly with her. However, I was with Mr. Watts most of the time. Another deputy was collecting the information because we had them separated in the parking lot.
And did you arrest the defendant?
Yes, sir.
What did you arrest him for?
For violating the injunction or the no contact order.
Today.
Morning, Deputy.
Morning.
When you spoke to Mr. Watts, he indicated to you that when he had seen her and he mouthed words, "Do you want me to leave?" he was a far distance from her, as he described it to you.
Yes, that's correct.
And he had also indicated to you that as soon as he saw her, he had texted his lawyer right away about what he should do.
Yes,
He showed you that text.
I believe so. Yeah, he did show me the phone.
And when you advised him he wasn't to be at that location, it's true also, is it not, that he indicated to you that as far as he understood, he was allowed to be at the gym.
Yes, as far as the
Objection, Your Honor?
Hearsay?
Sustained.
So, Your Honor, it's not hearsay because it goes to the state of mind of the defendant, not necessarily to the truth of the matter asserted,
Sustained.
and to the willfulness.
It's exculpatory and it's hearsay.
Okay. So he made some statements to you in response to your telling him he couldn't be there, correct?
Yes,
All right. And did he appear surprised that you telling him he couldn't be there?
yes.
Nothing further, huh?
Redirect?
Very brief, Your Honor. Did he tell you that he mouthed the words to her, or did he say that he spoke with her?
I don't remember which he said in mouthing or speaking.
You don't recall?
Yes, sir. I don't recall.
All right, thank you, Deputy Reed. You may step down, sir. The next witness, please.
Your Honor, we asked that Deputy Reed not be released.
Okay, yeah, if you'll just remain outside, Deputy, and just remember, your rule has been invoked, so don't discuss your testimony with anyone outside, okay?
Yes, Your Honor.
Thank you. Next witness, Ms. Maturin.
Yes, Your Honor, State Cross Deputy John Bardis.
Cover, if you would raise your right hand, face forward, please.
Do you solemnly swear or affirm that the testimony you shall give shall be the truth, the whole truth, and nothing but the truth?
Yes, I do.
Thank you.
Watch this.
All right, the main inquiry.
Thank you, Your Honor. Good morning. Can you please introduce yourself to the court and spell your last name for the record?
My name is John Bardis. I'm a deputy for the sheriff's office. My last name is Bartis.
Deputy Bardis, how long have you been with the Lehigh County Sheriff's Office?
22 years.
And what division are you assigned to?
A civil process.
And did you receive training to work as a deputy in the civil process
Yes,
unit?
of course I did.
And can you briefly describe what that training consists of?
And it was out of county training in civil process along with other law enforcement duties that we do.
And, can you explain, to the court what your process is when you serve an individual?
Well, protection order, we receive the paperwork from the office, and we try to locate the respondent. And we make contact, and we serve the protection order.
And can you, explain, what do you typically explain to the individual you serve an injunction order to?
I got my page 2, so I'll look at it.
Any objection if he refuses?
No, you're not.
All right, go ahead.
Typically, there's an order, it's a flat package that's processed by the court. We locate the defendant, not the defendant, the respondent, and we advise them to not have contact with that particular person who is the petitioner. Do not call, do not text, no contact at all. Next time you see him, it should be on the court date that's listed in the paperwork. And in addition to that, there's usually locations where you can't go, usually a residence, a school, or any other address that's needed by the petitioner.
And do you go over or review those addresses or with the individual you serve?
Yeah, we just highlight it. Just don't violate it, please, because if you violate it, you're gonna get jammed off the bus.
And now, turning your attention to June 5th, 2020, were you on duty that day?
On June 5th, yes.
And did you serve a restraining order on an individual who identified himself as Chad Allen Watts?
Yes, I did.
And did you tell the defendant who the petitioner was?
Yes,
And did you tell the defendant he was not allowed to have any contact with the petitioner?
absolutely.
And did you tell the defendant he was not allowed to go any of the addresses that were listed on the injunction order?
That's correct.
Or have anything further on?
Mr. Day.
No questions, Your Honor.
All right, Deputy Bartis, you may step down, sir. Deputy Bartis, be released.
No, Your Honor.
All right.
we're gonna ask you-
Sir, if you'll just remain outside, please don't discuss your testimony with any other witnesses. Thank you. Your next witness, Ms. Matrino.
Your Honor, the state rests.
It's called Diane Walton.
And come around the side, please.
Hey, Mr. Day.
Ma'am, on June 24th of 2020, were you employed at King Premier Properties?
Objection, Your Honor. Relevance.
Hold on a second. Hang on. What are we doing? This thing on this? Is this
Your Honor, I'm
a
gonna get
prior?
her just a second. I just need to get her.
Okay. All right. I'll give you some anyway. We'll see where we go from. All right.
Will
Overly
you-
objection.
Sorry, could you
Sure.
repeat the date?
On June 24th of 2020, were you employed at King Premier Properties?
No.
Objection, Your Honor. The relevance of this.
Well, we'll see what happens. All right. Overruled. I'm sorry, Mr. Day. Is it Kane? K-A?
CA.
K-C-A-I-N-E.
Okay. All right.
Is your email dianeben75@gmail.com?
Correct.
And would there been any reason in June for you to send out emails on the bottom under your name, King
Objection, Your
Premier?
Honor.
Yeah, that
Well,
was. a
hang on,
mistake.
ma'am. Just don't.
The relevance of what this has to do with a violation of the injunction.
No, I'm going to give Mr. Day a little bit of leeway here. Just a minute. We'll get to it, hopefully.
One of the email addresses, which was on my iPad, was never corrected. It said King Premier.
Okay.
And also when I would send property, and I caught that later, but I haven't worked there. Actually, you can look that up. State licensures are connected to addresses, and you can see exactly which company I worked for from what time frame.
So you do acknowledge in June 2020, then sometimes your emails went out and said that, even though you
If
weren't.
it was from an iPad, correct.
No further questions.
Any prosecutor? Mission?
No, Your Honor.
All right, Ms. Walton, you may step down, ma'am. Thank you. Again, if you would, just remain outside. Do not discuss your testimony with anyone.
Call Mr. Watson.
You would.
Do you solemnly swear or affirm that the testimony you shall give shall be the truth, the whole truth, and nothing but the truth?
I do. Yes, sir. Please follow.
State your full name for the record, spelling your last name.
Chad Allen Watts, W-A-T-T-S.
Mr. Watson, how do you know Miss Walton?
I've known her for 15 years. We were engaged for a little over 2 years, and we lived together.
Back in June of 2020, were the two of you separated?
Yes, we were.
And at that time, was there several disputes pending between the two of you, civil disputes, criminal disputes, and injunction disputes?
We just finished a
Objection,
domestic
Your Honor.
violence
Hold on,
charge.
hang on, stop.
The relevance of going into this.
I'll out for now. Ooh.
Were there multiple things pending? Not just a simple yes or no?
Yes.
Okay.
Multiple.
And was there an occasion where you were served with a temporary restraining order?
Yes, sir.
And the location where ultimately the police came in contact with you was a gym. What's the name of that gym?
Naples Family Fitness.
And how long have you been working out at that gym?
Since 20 years.
And the location of that property where the gym is, does it describe, if you could, just for the court, what that property looks like?
It's a massive property. I actually used to have an office in it. And it has that same address, and each one has a block. And it goes all the way around. And it has like probably 30 facilities on that particular block. So you have the gym, you have a vitamin shop, you have a walk, you have a poke bowl place, you have a eyebrow place, you have a vitamin store. I mean, it goes on and on.
Miss Walton, during the period of time that she was your fiance, did you know her to do eyebrow work?
That's what she quit working at her dentistry office. I set her up to become do permanent eyebrows.
And was it your understanding that she was doing permanent eyebrows at the waxing place at that same address?
From her lawyer and my lawyer's communication, I was told that she was working at the European Wax Center.
Okay, now just so the court understands that the building that you described, is it one giant building?
One giant building in wax job with does eyebrows in her hands. Yes.
You talk really quick.
Sorry, I'm sorry.
That's all right. So it's one large building,
Yes, sir.
and are there different businesses?
Multiple.
Okay. And is that the eyebrow wax center in that same building?
That same plaza, correct.
All right. Now, when you were served the petition, did you have an attorney?
At that time, yes, John Silverfield.
Yeah, doesn't matter who it is. Did she have a lawyer? Doesn't matter who it is.
I think Derek Runnemore.
Okay.
I think so. No, she hired him after.
All right. So was there a point where all the parties were discussing, trying to get all the matters resolved?
Correct.
And was it your understanding that you were supposed to stay away from her residence?
Correct.
And you were supposed to stay away from the location where the waxing place was?
That is correct.
All right. Were you aware prior to the police coming and being arrested, were you aware as to what the studio number of the gym was?
That is correct. I was not aware.
Were you aware that that number of that is actually 550?
No, sir.
Prior to the police coming that day and arresting, did you know that?
No, sir.
Now, are all of the businesses located in this building as you described the same address?
With a different block with a different number.
Did you know that the day you were arrested?
No, I did not.
So at the time that you were in the gym, was it your understanding that you could go to that gym?
Correct. 100%.
I don't have any further questions.
On June 5th, 2020, you were served a restraining order, correct?
Correct.
That restraining order states that you're not allowed to go in or within 500 feet of 2349 Vanderbilt Beach Road, 550 Naples, Florida 34109, correct?
Correct.
Yeah, you were at that address on June 21st, 2020?
Yeah, but if you do the mathematics and figure out the size of the buildings, there's probably 30 spaces in there over 3,000 square foot again. You can do the math and you'll know it's well over 500 feet from the European spot.
You've been going there for 20 years?
At least right back when it was lifestyle, and then LA Fitness bought them out, and then Jabs bought them out. Yeah.
And you didn't recognize the address on the restraining order?
No, why would I? I just know it's the gym. I work out at I have a gym membership at like 5 gyms. I don't know any of them addresses. I'm a workout athlete.
You have a membership at that gym?
Oh, of course.
At 5 gyms?
I have one at LA Fitness. I have one at Smash. I have one at the Expert. I have one at Athletica, and I have one at Nicholson.
So there are other gyms you could go to that are clearly not within the area of what was stated on the restraining order.
Yeah, but I like to do legs there on Sundays, and that's what I would go to at the time because they have the leg press machines.
The restraining order for stalking that was issued against you also states that you're not to have any contact or communicate with Ms. Walton, correct?
That's correct.
You walked up to her and spoke with her at the gym, correct?
I stood about, and then according to the police report also, and what did that testify? I stood back at least, other side of the gym. I see her walk in, she sat there and stared at me for at least 10 minutes at the entry, staring at me. I text Ian Holmes, John Silverfield, oh my God, Dinah's showed up to the gym, what do I do? I didn't text her best friend, oh my God, Dinah's here.
At that point, why didn't you leave?
She was blocking the entry. She was sitting there at the entry, and I knew if I got close to her, I'd get arrested. So I waited for her to go upstairs, and as soon as she started going upstairs, I tried to go out the door. She come running back down the stairs. There was no 20 minutes. As soon as I tried to make the entrance the way out to the door, she come running.
Did you speak to her?
For the distance, I said, what do you want me to do? You want me to leave? I went like this. What is that?
Watch your feet. I think your feet
My feet
are
are still.
the wire. Okay.
My feet are
Yes,
still.
just back away from this a little bit. There's a microphone, so you'll be good.
My feet are still on the same microphone.
Again, you've been going to the gym for 20 years. You know its location.
I do not know the address. I'm sorry, I do not. I can't tell you any of the gym's address, not one.
No further questions.
No further questions.
All right, Mr. Watson, you may step down, sir. Any other witnesses, Mr. Begg?
No, Your Honor. No additional.
You guys want some time to, or I don't know, is there any rebuttal?
No, Your Honor.
I'll give you guys about 10 minutes to collect your
I'm ready
thoughts.
now.
You ready? All right, then go ahead.
Thank you, Your Honor. The state had to prove 2 things today, Your Honor, that the defendant had a restraining order for stalking issued against him by a court to protect the victim, and that the defendant willfully violated that injunction. The state showed that the victim, Ms. Walton, applied for and received a restraining order from Judge McPhee against Mr. Watts for stalking. As you heard today, that order was served on the defendant by Deputy Bardis the same day it was issued by the court. You can also hear we put into evidence both the restraining order and the order extending the date of the effect of the restraining order to July 13th. The state also proved element 2 that the defendant, Mr. Watts, willfully violated his restraining order for stalking. The injunction stated the defendant could not go to the address of Naples Family Fitness Gym, which was included because it was a place that the victim and her family goes to, and the defendant knew that. The defendant himself admitted that he was at the gym. The defendant can't argue this wasn't a violation because he didn't read the order. Not reading the order that was served to him was not defense, even had the paperwork on him the day that he violated. Defendant's stalking injunction also states the defendant shall not have any contact with Ms. Walton, either directly or indirectly. He came up to the victim and talked to her twice. The first time he came up to her, he said, "We need to talk." And we learned that through the victim's testimony. The second time on his way out, he came up to her and the officer and said, "That is all yours, I'm leaving." The defendant violated the order 3 times by being at the gym and making contact with Ms. Walton twice. There should be no reasonable doubt in your mind that Mr. Watts violated his restraining order for stalking, and the state is asking you to find the defendant guilty.
The defendant in this case was actually at the gym before the petitioner from the injunction case showed up. I think that's an important fact, 1. Secondly, it's also important to note that, and this is confirmed by law enforcement, that when law enforcement gets there, he indicates to them a couple of things. One, and most important, is that as soon as he saw her, he texted his lawyer right away to find out what he should do, because he certainly knew he couldn't have personal contact around her. Now, if he was willfully intending to violate a no contact order, why would he text his lawyer, what should I do? I mean, it doesn't make any sense. It's contrary to that. That evidence suggests more, there was no willful intent to come in contact with her at that time. And the officer confirmed that he saw the text of the lawyer. We also know that from the defendant's testimony that the nature of this complex is that it is a large complex. It has the gym in it as well as many other places, one of which is a waxing and eyebrow place that she had been going to. It was his understanding that he had to stay away from that particular place, which, although is in the same building, is a substantial distance apart. The defendant did not recognize the address. The address for all these businesses is the same as far as the prefix of the address, which is the 2349. That is the same for all the buildings, but the suite numbers, which is the 550 part, apparently is the gym. He didn't know that before he went. He had been going to the gym all this time. There have not been any issues as far as that until that day. So he didn't realize that the no contact order specifically provided for that particular location. He was certainly under the impression that it was her residence and the place where she frequented for the wax place. The other thing I would also point out, Your Honor, is that the alleged victim in this case says that he makes a new statement to her that she did not disclose at the time of the discovery in this case. And she says that he makes some statement to her while he's standing outside in the presence of law enforcement, who by that time has him in custody, knows there's a violation of the no contact order, and apparently my client makes another statement to her, which certainly law enforcement would have noted as a violation of the no contact order and noted in their reports. None of that evidence is out because it wasn't noted by law enforcement, wasn't brought out in direct. I think that leads a little bit of contradiction to what she's saying. So the basic issue in this case, Your Honor, is whether or not there was a willful violation. And I think that the text information to his lawyer and the way that that happened shows that he did not willfully intend to violate that no contact.
Your Honor, the defendant admitted himself that he spoke to her and that he's been going there for 20 years. Not reading your restraining order issued against you carefully for stalking is not a valid excuse. You can't defeat a court order by making yourself willfully blind to what it says. He willfully ignored the contents of the restraining order by going to the gym and willfully violated the restraining order again by talking to the victim twice. We know one of those times from the victim's testimony that he himself, again on the stand, admitted to talking to her. The officer testified that he tells everyone he serves to read the injunction and likely would not have told them something contrary to what was in the order. We also know that he was served, and you heard from the officer who served him today. Ms. Walton's allowed to go to the gym that was specifically outlined in the restraining order as a place Mr. Watts was not supposed to be. It was put in the order because she and her family often goes there, and Mr. Watts was aware of that. Again, 20 years he's been going there. He knows he can't go to the gym that Ms. Walton uses frequently. Even if it wasn't on the order, he knows that he's not supposed to have contact with her, and going to a gym that he knows that she goes to would run the risk of him coming into contact with her. But it was on the order, and it was specifically outlined, and he's been going there for 20 years. The defendant had a restraining order issued against him for stalking, and he violated it 3 times June 21st. You only need to believe the state proved he willfully violated it once to find him guilty. And the state believes that it's proven beyond a reasonable doubt that he's violated it 3 times. Your Honor, the state again asks you to find the defending case.
All right. It's indicated by the state there are actually 2 elements of the offense. An injunction for protection was issued by a court against a benefit of the victim, which the court finds that the state's Exhibit 1 does show that that was issued. It was extended on another date under Exhibit 2A, as well as defense testimony that he knew and was aware of it. The injunction is pretty clear that the address, other than the victim's address, that it is at 2349 Vanderbilt Beach Road 550. The defendant, you would think, since it's a specific area, would try to know what that would be, simply because it's important, as he was explained by the officer, that he not get in any trouble by going to that address. And one would think that somebody would find out exactly where 550 is, as opposed to any other. His testimony is that he was told by the attorneys that she might be working there, but he had no personal knowledge of that, no direct knowledge as to whether or not she was working at the European spa. Haven't heard any evidence as to one way or the other where the European spa is located in relation to this, but be that as it may, it doesn't really matter. The defendant obviously did willfully violate the injunction. He went there at that place to do particular leg work that day. Whether he knew it, she was going to be there, and the fact that he was there before her, I don't think really makes a difference. He wasn't supposed to be there at all. And it's fairly easy. That's why the injunctions are specific enough so that someone can simply find out what that address is and not go there, which is what he should have done. But in any event, I don't give much credence to the fact that he didn't know that that was that address, especially since it talks about someone who regularly visits there, and it sounds like both of them were well aware during the course of their relationship that they both, in fact, did go to that particular gym. Court is going to find Mr. Watts guilty, going to adjudicate him guilty. It's going to impose a $1,000 fine plus court costs, including cost of prosecution.
Your Honor.
Yes, ma'am.
I apologize for interrupting. Can we check with the victim if she would like to be heard, if Your Honor would allow her to be heard prior to sentencing the defendant?
Okay, I should do that.
Give me 1 second.
You're on the officers were asked to stay. Can we release them?
Yes, they could be released. Thank you.
Your Honor, the court may proceed.
All right. I guess, Mr. Day, I should have asked if Mr. Watts wishes to say anything.
No, but I do think there's some mitigating facts that we should consider.
Okay.
So the evidence that was not admissible in the motion in limine, I think, is admissible in the sentencing phase of this trial. These two people had a number of different matters pending around June. She had been arrested for a domestic violence case against him. He had this petition pending against him, and they had a civil lawsuit pending also. They had, I will also provide a copy, Your Honor, of Marcus Defense Exhibit 2 for sentencing purposes. On the 24th of June, she emailed my client, an email. Provided to the court. Marcus Defense Exhibit 2. This was after this incident of the airport day. 24th of June. You'd also, Your Honor, on Marcus Defense Exhibit 3, when my client was being arrested, she was photographing my client and sending copies of the photograph to my client's son and children. And that's marked in Defense Exhibit 3. And here's the significance of all that, Judge. Obviously, there was some contentious litigation going on between these people and all this matter. They had hired lawyers finally around the time that all this happens and tried to resolve all the matters between them. They resolved the personal property matters. She had been arrested for domestic violence battery against my client. There was an agreement that he would get rid of that and she would get rid of this and everything would go away. It all sounded great on paper. He filed a drop charge request. Her charges were dismissed. The petition for injunction went away. And then nothing ever happened with this case that was supposed to happen. Now, the state's not required to. I'm not suggesting they are. The state can do whatever they want to do. But I think it's important, at least for the court, to note, if you use the term victim in this case, it's used a little more loosely. These parties were tit for tat back with each other and lots of different things. But the reality of the world is that everything is going to be resolved. They haven't had any contact since. Everything's fine. And then this case just continued to drag on. I think no one's solved COVID, and here we are today. I just want the court to take note of those things. I mean, there was lots of other times that she would text and email. I don't think it's of any significance other than to show that I don't think she's in fear. There's no danger to her in any way. She not only was corresponding, she would send emails to family and friends, negative things about him all the time. So it was more than just this case going on. Nothing else has happened since that date. And I think we've been since COVID waiting to get this case. I think those are important factors for at least the court to know about in determining the likelihood of any future criminal activity, I think is remote at best. He also has no prior criminal history. So there's nothing that reflects any other prior unrelated issues to this department. I just wanted to bring all those things to the court's attention regarding what was going on between these parties at the time.
Thank you. State, anything?
Your Honor, as Mr. Day is bringing up what was going on with these parties, the state would like to point out he did not in fact have a criminal record. However, according to Jansen versus State 399 Southern 2nd 1061, the court is allowed to consider the defendant's prior arrests, even if they're not convictions. In this case, he does have a prior battery from 2012 that was dropped, a burglary and a grand theft from 2014. He's got a battery and a harass and cyber stalking from 2018, and he's got a prior violation of injunction in 2018. And additionally, regardless of what was going on between the parties, whether there were other civil matters or not, this defendant willfully violated a court order from a judge, and did so without any disregard for that court order. So we would request the state's, if the court may allow us to put on the record what the state's recommendation offer in this case would be.
Go ahead.
Your Honor, the state in this case would request an adjudication, 12 months probation, no early termination, 15 days weekend work or weekend lockdown, batter's intervention program, mental health evaluation, follow all recommendations, no contact with this victim, no trespass at the gym or at the victim's residence, court cost and cost of prosecution.
Anything you want to add, Mr. Day?
Just brief response, Your Honor. The plea bargain in this case did not contain any jail, so I don't know what has changed in 24 hours, other than they want to punish the man for going to trial. I know the court's not going to do that, but he exercised his right to trial for several different reasons. There was mitigating factors, I think, in this case, and those are the mitigating factors I brought up to the court. What was going on between these two is mitigating. The state didn't see that as mitigating, even though the state had no problem dropping the charges against their alleged victim at the request of my client. They seemed fine with that. And when it came time to do the inverse, they all of a sudden dug their feet in and wouldn't do it. So, and the mental health evaluation, there's no indication he has any mental health issues. I don't know where that comes from. That's not appropriate in this case, and neither is the jail.
All right, well, sometimes they tell you wake up every morning to be grateful. I'm grateful I don't do family law. although we see enough of it here in domestic violence. And usually it's a two-way street, and it's just sometimes a question of how she's violated the injunction just as much as he has by sending documents into him, and they're still communicating, and then it seems like it. But what I'm looking at is a court order that says you can't have any contact and you can't go a particular place. And well, I got 5 other gyms, but I'm still gonna go to this one. So I think there needs to be some kind of consequences based upon that. I don't care whether you violate it by talking to her or not talking to her, but there is a court order, and I think that at least if we're going to have a society that follows any rules, then we need to follow the rules, and they're laid out in writing, and you've got more than enough time and notices to find out what exactly it means. So I am going to adjudicate him guilty.
I don't mean to interrupt. He'd like to make a statement, and before you sentence, I think he's entitled to.
All right, well, I'll give him that opportunity.
Yes,
Okay.
Your Honor.
Yes, sir. Go ahead, Mr. Watts.
Oh, sorry. I'm a single father of 3 people.
And let me just make, well, go ahead, never mind. I won't say
2
anything.
businesses. When the server came and I see that address, I specifically asked him, I said, is that the gym? He goes, no. I think the gym's farther down. It's farther down from there. I had no intent to break this. I even have emails from my lawyers thinking that it wasn't it. I have 0 intent. I have not contacted her. I received emails, I haven't replied back. I understand that I did break the rule, but what I'm telling you is that I've shown 8 months of just avoiding her. I didn't reply back to that email. I didn't reply back to the pictures she sent my mom, my brother, my aunt, my sister, my stepsister, my stepbrother. She said all to my family. I paid enough. I don't even have my family now. They're just like, stay away from us. You're crazy. Like my mom and my dad, after they get all these pictures from her. I do agree. I made a mistake. I depended on, I have all this stuff going on. I have kids, I have businesses. I take care of so many people. I did not willfully intend to violate this at all. 0. Why would I give up everything I got and custody of my kids to violate something this petty? And it's not petty. I mean, it's law. I understand, but it is not. I understand I need some kind of punishment, but I'd rather serve the community in some kind of way and help out less fortunate than to not do something. You understand?
Yes, sir.
I'd be glad to do some kind of volunteer service work.
All right. Well, I'm not going to put you in jail, Mr. Watts.
I understand, but I did not willfully do this, sir.
Well,
I'm sorry.
Go ahead.
Something that was important to the victim that can be failed to mention our recommendation was GPS monitoring. Sorry, I drove it.
All right.
Your Honor, if I may. I'm sorry. That is not fair to me because
Do me a favor, don't pull your mask down.
I'm sorry.
It's not, listen. You might want to let me practice a little law here.
Okay, sorry.
Okay?
Okay, I'm so sorry.
Practice law, it really goes bad sometimes.
I understand.
Okay?
I'll be quiet.
And the court sometimes will ask me questions when the court has questions. If he doesn't have questions, let's let him do it.
I understand. I apologize, sir.
All right, no problem.
Anybody else have anything to say?
No, sir, Your Honor.
No, Your Honor.
All right. Mr. Watts, the court's going to adjudicate you guilty, impose a $1,000 fine plus court costs, include the cost of prosecution. We'll place you on probation for a period of 3 months. That'll bring us almost to a full year at that point in time. As a condition of your probation, you're not to have any contact with the victim and no trespass at this particular gym. Family, I'll spell out the name of it so we don't get confused. Since you indicated you've got other places that you can go, we'll have you go there. But the Naples Family Fitness, you can't go there at least for the next 3 months, okay?
Yep.
All right, you'll need to see the probation department this morning before you leave. We'll have you fingerprinted by the bailiff. If you have her, yes. This, as far as Mr. Davies exhibits 2 and 3, we'll just put those in the court file. I didn't admit them in that, but I did consider them for purposes of sentencing.
And
the DVP was presented but not admitted.
Yeah, that's correct.
All right,
Do I see
usually if it's marked, the clerk gets it,
Oh, okay.
even though it hasn't been. Okay.
And did you announce a no passing?
We did.
Count two, I think. Yes. Okay. Got it. Yes, ma'am.
Thank you, Your Honor.
Thank you.
Thank you.